Okay. So if the city removes the city-owned parcel, terminates all its leases, which it can do, all the leases are written to end in 2015. So if you terminate them by their terms, by the written terms of the lease, you're doing the legal minimum, right? You're not required to renew them, you're just required to obey them as long as they're there. When they're over, July 1 of 2015, you're doing the legal minimum. If you extend them, then you're saying, hey, let's do more than the legal minimum. Let us voluntarily help the FAA pollute the air. Okay? Then if you do the legal minimum required to maintain a safe aviation operation, well, that would be that smaller airport. You want to make sure it's safe. You want to make sure the bathrooms are clean. But if you don't have to do anything more than provide a bathroom that's clean and a safe airport, maybe it's not going to be used that much. I mean, if you stop selling aviation fuel, can you imagine landing a jet, paying steep landing fees because the city's no longer subsidizing the airport? Those landing fees go up through the roof. If they actually have to pay the actual cost of running that airport, those landing fees will tell half the users not to go there. If all the flight schools are gone because the leases have ended, and once again, if you're doing the legal minimum, once a flight school lease have ended, why would you renew them? Then you don't have much use of that airport with its little tiny landing strip that nonetheless complies with legal obligations. Now, you have the 1948 Instrument of Transfer. What do we know about that? Dead hand of the law, right? And you don't have to know much about that. It's the FAA. You don't mess with them. And then you can mess with them later, by the way. July 1/15 passes by. You close down as much as you're legally allowed to. How about August 1 of 2015? You could start messing with the FAA if you wanted to. Okay, so that's the instrument of transfer. Then you have the airport agreement. Now, that airport agreement, that's a tough document, and it's ended. You wonder, saying, how did this failure of democracy happen? One way it happened is because the city of Santa Monica agreed to it. Instead of saying, let's do the legal minimum we have to do, they said, let's get fancy about this and have all these pros and cons and compromises and politically expedient things and put it all into agreement that actually improved things a great deal back in 1984, but went far, far, far beyond the legal minimum and violated the city's own policy of saying, let's close down this airport as soon as we possibly can. So that 1984 agreement nonetheless is a legal document. It has to be respected. City Council has to be respected. The Airport Commission has to be respected. And the homeowners and apartment dwellers in this audience have to be respected. This was a compromise. It was not the legal minimum. This compromise ends July 1 of 2015, and it represents a failure of democracy. But it is the fault of every one of us. It's the fault of every one of us if this failure of democracy continues past July 1 of 2015, because that's when this agreement ends. Now, the land controlled by this agreement, here's the key part. The land controlled by the agreement is only the general aviation parcel and the city-owned parcel. That means when the agreement ends, and we're going to go way back up to the top again, when that agreement ends, you release the city-owned parcel. You no longer have to use it as an airport. You could come in the next day and drill holes in the runway. You could drill holes in the runway. You ever see those little stakes that keeps vehicles off of jogging paths, the little 3 foot high? You could put those every 6 feet. By the way, it would only cost like $10,000. I mean, I'd be happy to put in $1,000 for that. As long as I could put one in myself. Okay? Then the non-aviation parcel, that's already free. So come 2015, you're talking about these two parcels, city-owned, non-aviation, being free of the airport. Why would you possibly use it for airport operations if you legally did not have to? If you were committed to do the legal minimum, you wouldn't use it for airport operations at all. we said, here is a very interesting point. This says, the parties recognize and agree that it is appropriate for the city to exercise its proprietary authority to adopt ordinances applicable to lessees and users. Well, wait a second, wasn't that what Phil talking about, the proprietary powers? Didn't we hear some people in the audience saying, well, do you really have them? Or maybe up here, do you really have proprietary powers? Well, gee, if we don't, the FAA must have made a huge mistake, because here's the FAA agreeing that the city may exercise its proprietary authority. And if the city chooses to exercise proprietary authority by doing the legally minimum it has to do to operate the airport, then you're complying with Section 14. Now, 1994 grant assurances, what that is all about is that is a foolish argument. It's a foolish argument made by smart people who are trying to get you to go somewhere you don't want to go. What it says is, we gave you money, you're supposed to use that money for the purpose it's supposed to be for 20 years. At one point, they gave the money, they made a small change in language in 2003. They said, the 20 years doesn't start when it's obvious that everybody agrees it starts over here. It starts in 2003. It's a foolish argument, it should be recognized as such, and you really don't have to know. But what you do have to know is that the airport parcel map is what you got to remember. 2/3 of the airport can go away in 2015 if we do the legal minimum. This 1981 Santa Monica City resolution is the law of the city. It's the policy of the city that says we want to close this airport as soon as practicable. How could you possibly adopt a single budget subsidizing the airport after 1981? They adopted 30 of them, and the current budget is subsidizing the airport. The 1948 Instrument of Transfer, that is the dead hand of the law. We don't mess with the FAA. Maybe in a couple of years we might be in a position to, but right now we say go ahead and use that minimus airport according to what we are legally required to do. Let's keep the bathrooms clean, but that's about it. And then the 1984 Santa Monica Airport Agreement, that's where the failure of democracy can be fixed, because that agreement ends. If there's been a failure of democracy, every person in this room, every person is in a position to fix this 30-year failure in the upcoming times. And then finally the grant agreement that is going to go away before 2015. Gentlemen, thank you very much. Thank you very much.
Woo.
Thank you.
Yay.
I've heard raised in the past that has some relation to the 84 agreement, but is more general, so you may or may not be able to answer it. And I don't really know what the federal government's eminent domain rights are, but if I'm not mistaken, the opening paragraph, I think, of the 84 agreement contains an acknowledgement that was signed by both the city and the FAA that the Santa Monica Airport is an integral and necessary part of the national, aviation network. And the argument I've heard raised in the past was that that acknowledgement basically sets or lays the groundwork for a possible eminent domain, taking condemnation type of action by the FAA or the federal government, should they choose to do so, because of the essential and integral part that the Santa Monica Airport plays in the aviation network. So it's not so much an obligation created by the 84 agreement, but maybe an admission or an acknowledgement of something that might be damaging to the city should push come to shove with respect to taking some of these parts that may be city owned and legitimately taken off the table, as demonstrated here,